Last chapter ended on a warning. Identity is the most regulated substance in health data. So here is the law in the one shape you actually need. To use patient data outside the full weight of HIPAA, you have to de-identify it, and HIPAA gives you exactly two doors. Door 1 is safe harbor, a fixed checklist. Remove a specific list of identifiers and you're done. Door 2 is expert determination. A qualified statistician certifies that the risk of re-identifying anyone is very small. One is a rulebook. The other is a risk judgment. Which door you walk through quietly decides what your product is even allowed to do. Walk through door 1, safe harbor, and here is the actual checklist. 18 identifiers you must strip out. Names. Every geographic detail smaller than a state. Every date more specific than a year. Phone, fax, email. Social security, medical record, health plan and account numbers. License, vehicle and device numbers. Web addresses and IP addresses. Biometrics and full-face photos. And a catch-all, any other unique code that could point back to a person. Remove all 18. Confirm you have no actual knowledge that what's left could still identify someone, and the data is no longer PHI. It's clean, auditable, and brutal on utility. Your precise dates collapse to a year, your address collapses to the first 3 digits of a zip. Door 2, expert determination, is for when Safe Harbor destroys the data you actually need. A qualified expert studies your dataset and certifies, with documented methods, that the risk of re-identification is very small. In exchange, you can keep more, shifted dates, finer geography, the granularity your model lives on, more utility, more expertise, more ongoing responsibility. And there's a third option most people miss, the limited dataset. It keeps real dates and city-level geography, so it's genuinely useful, but it is not de-identified. It's still protected, and you can only share it under a signed data use agreement. And if you keep data fully identifiable, you're now in consent and IRB territory. Utility and freedom pull in opposite directions. Every step toward richer data is a step toward heavier rules. Now, the single most important sentence in this chapter, de-identified is not anonymous. Safe Harbor doesn't make re-identification impossible. It lowers the risk to a defined threshold and then stops. Because a surprising number of people are unique on just a few coarse facts. A birth date, a sex, the first digits of a zip. Take a supposedly de-identified record, line it up against a public voter roll or a news story, and the person can snap right back into focus. That's a linkage attack. And the risk spikes exactly where your data is most interesting. Rare diseases, small towns, precise timelines. So when a vendor promises you anonymous data, hear it precisely. They mean de-identified to a threshold. The residual risk didn't vanish. It became your responsibility. Zoom out, and every privacy conversation is really about 3 states of the same data. Pseudonymized, the identifiers are swapped for a key, but the key still exists, so it's reversible. Under Europe's GDPR, that's still personal data, with the full rulebook attached. De-identified, HIPAA style, enough removed that it's no longer regulated PHI in the United States. And anonymized in the strict GDPR sense, truly irreversible, no longer personal data at all, outside the regulation entirely. Here's the trap that catches global teams. The strict version is so hard to reach that, as the saying goes, a truly anonymous dataset is an empty one. And data you've perfectly de-identified under HIPAA is very often still personal data under GDPR. One label, 2 continents, 2 completely different legal realities. So you can now do the thing most teams discover far too late, in the middle of a deal. Pick a compliance posture on purpose. Safe harbor or expert determination. A limited data set under an agreement, or fully identifiable with consent. De-identified for the US, or a real run at anonymization for Europe. Each choice trades utility against freedom, and each one silently defines what your product is allowed to become. Now, the honest disclaimer. This is a map, not legal advice. It tells you which questions to ask and which words actually mean something, so that when you sit down with a real privacy lawyer, you are choosing your posture, not discovering it. And this whole chapter assumed the data was already yours to hold. Next, the the supply chain that actually moves it. Chapter 6. Who has your data and how it's bought and sold.